School. Good morning, everybody. I'm Chief Justice Stanfield. And ordinarily at this point, I also would have sat down and would call the next case. But before we do that, I just wanted to have a few words with you about what we're going to be doing here this morning, and thank you for having us here. This is very interesting. We really have lights in our eyes, so I can't really see you very well. But I know there's people out there. As I said, I am Chief Justice Stanfield. I am the Chief Justice of the Maine Supreme Judicial Court, and I'm here with my colleagues. And we are doing what we do every month, which is hearing appeals from cases. We don't do trials ordinarily in our Supreme Judicial Court. These are cases that have already been tried in the trial court or otherwise ruled upon by the trial court and coming up to us with a question that somebody's arguing that the court below erred in some fashion. I want to thank you, as I say, for having us here, and I want to recognize some of the people that are here today. Is the principal here today? Somewhere out there? I can't really see. There you are. Okay, over to the side. And we also have with us, I guess, Maureen Sturdivant and James Spizzuco over here. And they volunteered to act as lawyers today to help answer some questions because we really can't talk to you about the cases that we hear today. We also have with us some of your legislative delegation, Representative Zager, who I think is here somewhere. There he is. Why don't you stand and wave, everybody? There we go. Speaker Talbot Ross, who we are honored to have here today, as well as Representative Ed Crockett. And I want to also particularly thank the coordinating faculty. We give the materials ahead of time so that you can be a bit more prepared for this morning. And I believe that's, I'm going to mispronounce these names, I'm so sorry. Melissa Thoitz, Chuk Luan, Leanna Littig, and Liz Davenport. So thank you to all of you for coordinating all of this. And finally, it's also important to thank the custodial staff as well as the AV setup, auditorium setup, because it does take a bit of doing to get us in here with our special little light that turns colors and our staff here as well. These proceedings are being streamed live on the web, so that's also one of the things that we do all the time so that people can see what happens in the Supreme Judicial Court. As I say, I am the chief. I have my chambers in Augusta. Ordinarily, in a lot of states, everybody's in one place, but we maintain our chambers in different places across the state. And so what I'm going to ask is my colleagues to introduce themselves. I will say we are very tradition-laden, and we do everything in order of seniority. And by that, I mean seniority on this court, not who's the oldest person, or for that matter, who has been a judge the longest. I'm automatically considered the most senior just because I'm chief. But I have, in fact, although I've only been chief, I'm in my 4th year as chief, I've been a judge for 18 years as well. So I'm going to let my colleagues introduce themselves, and we will start with our most junior justice.
Good morning. I'm Wayne Douglas. Pleasure to be here. Thank you for having us. I've been a judge for a little over 20 years. I started out on the district court. I spent some time on the Superior Court, and I've been on this court for a little over a year and a half. So thank you again for having us.
Good morning, I'm Rick Lawrence, and again, I also am very happy to be here. Thank you for the invitation. I have my chambers here in Portland, and I've been in the court system for 24 years, 22 of which were on the district court before coming on to the Supreme Judicial Court.
I am Catherine Connors, and I'm kind of the middle senior when it comes to this court, but I'm very junior when it comes to being a judge because I'm the one who has never been a trial judge. I've been on this court starting in February 2020, and before that I was in private practice in Portland, and my chamber's in Portland.
Morning, everyone. My name is Andrew Horton. As you can see, we're seated by seniority, more or less. We've been going back and forth toward the middle. I practice law here in Portland with a firm for a number of years. I became a trial judge in 1999 and served for about 20 years on the trial courts, and then I joined this court in February of 2020. And I also want to thank the school and you all for inviting us here, and I hope you find it interesting and informative.
Good morning. My name is Andrew Mead. My base of operations is in Bangor, although the court holds forth in Bangor, Augusta, and Portland, so I'm on the road a lot. I've been a judge for 34 years, the last 18 of which have been on this court. I serve as the senior associate justice, although that doesn't mean that I'm the oldest member of the court. We are delighted to be here today. This is terrific. Thank you to the representatives who invited us and to the school that has hosted us. We're looking forward to this, and I hope you are too.
Ordinarily, by the way, we are supposed to have 7 members. We have an empty seat, which is why we're a little off balanced here. I should have 3 on each side of me, but it doesn't work out that way. With that, I'm going to call the first case. The matter is Cumberland 23-508, State of Maine versus Billy Beaulieu. We are, as I mentioned, being streamed live on the web. I would ask counsel to identify themselves by saying their names for the record, together with the party they represent, starting with the appellant.
Max Coolidge for the appellant, Billy Beaulieu.
Good morning, Your Honors. Clio Barr, student attorney for the state of Maine, the appellate.
Thank you. And Mr. Coolidge, if you're ready to proceed, we'd be happy to hear your argument this morning.
Thank you, Your Honor. Chief Justice, and may it please the court. The statute at issue in this case is intended to save lives. And it only does so if people like Jennifer Dunning and other concerned citizens trust it to work. The drug overdose epidemic is a complex social issue, and there's likely not one magic bullet solution. But one thing that is clear is that quick response to possible drug overdose will save lives. And on the flip side, hesitation and delay can mean death. Understanding this, our legislature enacted the so-called Good Samaritan statute. The statute is targeted at a particularly deadly source of delay and hesitation: the fear of the very real threat of criminal prosecution. Jennifer Dunning believed on September 24th, 2022, that Officer Scott was a person she could count on to check on the well-being of another person. She did not summon the police to protect herself from harm, and she did not summon the police in response to a perceived threat to public safety. The trial court stated that Jennifer Dunning would have no reason to hesitate and no fear of prosecution because she described her concern in terms of a medical event. Knowing now that her sincere concern for a fellow human being got that person into serious legal trouble, charged with a Class C crime, she might hesitate next time, and others like her might hesitate next time, and that hesitation could be deadly. There's a simple bright line rule that can be adopted here that I would urge the court to adopt, and it's the approach the Georgia Court of Appeals took in a case interpreting that state's medical amnesty statute. If the police are present solely because of a concerned citizen's call for help, and the objective circumstances could be a suspected drug-related overdose, the immunity under Section 1111B should apply. It's an easy rule for the police and prosecutors and the courts to apply. It's consistent with the intent of the legislature, and most importantly, it will save lives. I'm asking the court to reverse the decision of the Unified Criminal Docket in this matter, and I'd be happy to answer the court's questions.
So what happens if somebody calls in, given the language that says it's suspected drug-related overdose, and they say, I see this car on the side of the road, and I think he's had a heart attack. Is that the Good Samaritan rule?
I think under circumstances in like this, where it turns out that there was in fact some drug-related issues going on, I think it should apply.
So your test is whenever anybody calls and says, I see somebody on the side of the road, it looks hinky, and it turns out to be a drug overdose, that's it.
I think that's a good rule. I think that rule will save lives, Your Honor. I think that.
Did it in fact turn out to be a drug overdose in this case?
It turned out there was drug involved in this case.
There was drug involvement. That's not necessarily the same as an overdose, is it?
It's certainly not the same necessarily as an overdose. We don't know what may have happened as time went on in this case if Officer Scott had not been summoned.
Was the officer dispatched to the location of a medical emergency? And obviously, I'm using the language of the statute here.
Yes,
You
Your
can
Honor.
talk about what other states have done, but we're bound by the language of our statute, right?
Yes.
Okay.
Yes,
So
Officer Scott.
it requires being dispatched to the location of a medical emergency.
Yes, Officer Scott was dispatched. Officer Scott was dispatched.
He was dispatched.
He was dispatched.
But was he dispatched because of a medical emergency? It seems to me that what happened here was that the independent witness saw a car at the side of the road, and by the way, it was 2 hours later when it was still there, which doesn't that kind of undercut the idea that it's an emergency, that she asked the officers to check it out? Isn't that what happened?
She certainly did. She asked, and she described it as a concern for a medical event. I think that's enough to meet the definition of dispatch to the location
So
of.
does this turn on whether she used the word medical event, or gee, I just wonder what's going on and if everything's okay?
I don't think it necessarily in all cases has to turn on whether she described it as a medical event. Her concern for the well-being of the driver is I think the controlling factor.
The statute uses the phrase suspected drug overdose. Who, in your view, has to have that suspicion?
I think that's an excellent question, Your Honor. I think that it's an objective standard, I would argue. I think if we require that there be magic words used or asking that we decide whether the person calling had that subjective belief, I think that makes the rule more difficult to apply and prescribes it too narrowly.
So I'm confused by your answer a little bit. Can I clarify that?
Of course, Your Honor.
So are you suggesting that as long as somebody calls for an emergency, if it turns out to be a suspected drug overdose regardless, I mean, they don't have to believe it's a drug overdose?
I don't think so, Your Honor.
And they don't have to say, we think it's a drug overdose?
I think imposing that requirement, imposing that they say it's a drug overdose.
Then why is the word suspected used? Your test is if somebody calls in for whatever reason and it turns out to be a drug overdose, they're covered. Why is the word suspected there?
I think the word suspected, well, the circumstances of the objective circumstances could be a suspected drug overdose. We also don't entirely know what was in Jennifer Dunning's mind. The circumstances of what she saw could certainly lead a reasonable person to believe that given what we know about the drug epidemic in this country, in this state, that could have been very easily one of the reasons the car was pulled off the road.
Can we just back up for a second?
Of course, Your Honor.
What you offer some opinions on what you think the law should be and what you think how it should be interpreted, but you've teed up an issue, what we call statutory interpretation. Legislatures passed a law, they've used certain words, and we have to interpret what they've said there. The statute here says, when a medical professional or law enforcement officer has been dispatched to the location of a medical emergency in response to a call for assistance for a suspected drug-related overdose, then everything follows from there.
Yes, Your Honor.
So the key language here seems to be a call for assistance for a suspected drug overdose. Now, when we do statutory interpretation, the first thing we do is just look at the words themselves and see if we can glean from it what our legislators intended. If we determine that they're ambiguous, then we go to other things like legislative history, what was said during the legislative process. Now, you have said that you think that that's ambiguous, that call for suspected drug-related overdose. Is that your argument?
Yes, Your Honor.
Okay. As I look at it and read the words together, it seems to me that the call has to be, I think there's a drug overdose. I think there's a suspected overdose. And that leads back to the question which was asked to you, which is, who is making the suspicion of drug overdose? The only person who could possibly have that suspicion is the person making the call. which means it's what we call subjective. It's in that person's mind. Your response?
Thank you, Your Honor. I think the objective circumstances matter. I believe that matters. What's in the person's mind, I don't think can be entirely gleaned from any record. She said, "I'm concerned about a medical event." We don't know if she was saying that euphemistically. We don't really know what's in her mind.
It was not a call for assistance for drug overdose. It was a call for, there's something, I have a concern there, I need a wellness check. The car hasn't moved, there's a guy in it. That's the four corners of what happened here.
I think the word suspected is what gives it the broader interpretation, that the person doesn't have to positively identify a drug overdose. If there are circumstances that are suspicious of a drug overdose and someone's calling saying, I think this person should be checked on.
I realize we have legislators sitting here, but trying to get into their minds is what they intended here. I think there was, which is always a tricky process.
Yes, Your Honor.
What they're attempting to accomplish with this law, and I think at the time there was a concern that if some people are together and they know that Jones here has taken some drugs and he's down and seemingly unconscious, they might be afraid to call because if the police come, they might be arrested, they're right there, they're involved with it. And they wanted to motivate these people to save lives, to go ahead and make the call, you're not going to be arrested. Doesn't that offer, if that's in fact the motivation, doesn't it offer a powerful support that the purpose here has to be for a suspected drug overdose?
It does have to be for a suspected drug overdose, Your Honor. I completely agree. That is the language of the statute. It's interesting, the scenario Your Honor described about people who are together, friends, the lower court used that word. It said the purpose of the statute is to make people, so they aren't afraid to call the police and say, my friend is overdosing. It's interesting that the legislature chose to title this law the Good Samaritan Act, the Good Samaritan Statute. The story of the Good Samaritan is about strangers helping each other, not about friends. It is about a stranger stopping to help another person.
But under your interpretation, somebody could call and say, I think this person's got heat prostration. They're at a concert and it's 100 degrees and they pass out. And they say nothing about drugs. So somebody comes in not prepared to deal with a suspected drug overdose, and they're prepared medically to deal with heat prostration. Under yours, if it turned out that they had some drugs in their system, would that make him immune from prosecution?
Yes, and that's the rule that the Georgia court adopted for their statute. I understand it's interpreting a different statute. But I think the rule makes sense. If the police are there to render aid, we're hoping that someone coming for a medical emergency is going to be carrying Narcan, is going to be prepared.
But doesn't that raise another question here? In fact, when the officer arrived on the scene, although it appeared, and then the jury found that Mr. Beaulieu was under the influence, it was not an overdose. He wasn't rendered emergency aid on the scene. He wasn't given Narcan. He wasn't taken to the hospital. He was simply under the influence, apparently, of drugs.
Well, he was woken up by the officer, and I guess
He was woken up.
He was woken
didn't
up.
require any medical treatment, though, did he?
He didn't immediately require medical treatment. We can't know what he may have needed had time gone on, what drugs were in his system, how they were interacting.
Well, to be clear, he wasn't given any medical treatment at the scene, nor was he brought by the officer to a hospital or medical, right?
That's correct, Your Honor.
Okay. So doesn't that, if he's a protected person, has to be a person who is experiencing a suspected drug-related overdose? And was he in fact experiencing a suspected drug-related overdose?
He was certainly experiencing a drug-related condition. And the focus really is not on him, but on Jennifer Dunning. We want her to call, regardless of the circumstances, and if we interpret this broadly in the way I'm suggesting, more people will be willing to call, more lives will be saved. I see the red light is on.
It is.
Thank you, Your Honor.
And Ms. Barr, we'd be happy to hear your argument.
Madam Chief Justice Stanfill, Associate Justices, Counsel, may it please the court. This is a case about straightforward statutory interpretation. The plain meaning of the statute is clear. The immunity provision is only triggered if a law enforcement officer or a medical professional is dispatched to the location of a medical emergency in response to a call for assistance for a suspected drug-related overdose. That's not what happened here. Title 17A, Section 1111B of the Maine Criminal Code, what I refer to as the immunity statute, serves an important purpose about which appellant and I agree. It protects public safety and saves lives that might otherwise be lost to overdose by eliminating a main barrier to calling for help, namely the fear of criminal prosecution. The impetus for the immunity statute is necessarily a legislative trade-off, refraining from the prosecution of drug offenses in the hopes of preventing more lives lost to overdose. However, we cannot solve one public health and safety issue, drug overdose, by exacerbating another one, driving under the influence. And the plain meaning of the statute cannot be read to create the illogical result of creating a loophole to let people off the hook for OUI. Part of recognizing the importance of this law is understanding the narrow subsection of cases to which it applies. That this immunity statute is meant to be limited in its application is underscored by the long list of excluded crimes that do not qualify for immunity built into subsection 1. This court does not need to look further than the plain language of the statute to see that appellant here does not fall under the carve-out of protected persons immune from prosecution. Your Honors, the trial court properly denied appellant's motion to dismiss due to immunity from prosecution under this statute. First, as a threshold issue, this appeal is interlocutory and is not immediately reviewable by this court because it doesn't fall under one of the exceptions to the final judgment rule. Delaying this appeal would not irreparably deprive appellant of a substantial right because immunity from prosecution is not a substantial right, and appellant would have the opportunity to argue upon appeal from a final judgment. Moreover, the statutory language is clear. The immunity protections afforded to persons pursuant to this statute are not available unless a medical professional or law enforcement officer is put on notice by a dispatcher that they are responding to a medical emergency for a suspected drug-related overdose. Here, the concerned citizen, Jennifer Dunning, informed the police officer that there may have been a medical event, but said nothing to suggest it had to do with a suspected drug overdose, as required by the statute to invoke immunity. Accordingly, appellant's not entitled to immunity from prosecution for the crime of OUI, and this court should affirm the trial court's denial of appellant's motion to dismiss. I welcome this court's questions.
You said, you touched on an issue that we neglected to talk to Mr. Coolidge about, and that is whether this is an interlocutory appeal. Ordinarily, we only hear appeals from final judgment, and in this case, the criminal prosecution hasn't gone to trial yet. Rather, it was an appeal from the judge's order denying immunity, correct?
That's correct, Your Honor.
And you also said that immunity from prosecution is not a substantial right, but hasn't immunity, in fact, certainly in the civil context, been exactly the kind of determination that we have taken as an interlocutory appeal? Because immunity from prosecution, or any immunity, means you can't do it. It's not a defense. It means you can't do it in the first place. Why shouldn't that be appealable?
Well, Your Honor, as you said, the only time this court has taken an interlocutory appeal, as appellant suggests, as a death knell exception to the final judgment rule, has been civil cases. This has never happened in the criminal context. And additionally, there's nothing in the statute that guarantees anything beyond what appellant has already done here.
But the point of taking an interlocutory appeal when the legislature says that someone is immune from prosecution, and in the civil context, they're immune from being pursued, is the concept that they're not just immune from being held liable, they are immune from having to go to court, from having to go through the process. And the death knell is killing that immunity from going forward. So why wouldn't we have the same analysis for a criminal context as a civil context when the legislature uses immunity from and then indicates its immunity from the process itself?
Well, we would have the same analysis here, Your Honor, because the substantial right has been obviated by the fact that appellant here is not immune from prosecution. That determination was made at the trial court level.
But that's the issue. And that's the difference between being immune from prosecution versus having this. If this had been phrased as defense, obviously, then it wouldn't be able to be appealed at this stage. But as Justice Connor said, the whole point is that you shouldn't have to even stand. Immune from prosecution means you shouldn't have to stand trial that's correct.
Counsel, the statute also says immune from arrest or prosecution. So should we read that to mean that when the officer arrives on the scene, if he determines that it is in fact a suspected drug overdose, can't arrest the person?
Well, Your Honor, the statute does say that, but the impetus here is the dispatcher. There has to be contextual information relayed by the dispatcher to the medical professional or the law enforcement officer. Jennifer Dunning did not do that here. It could have been, as Justice Connors said previously, any medical event, pulled over to the side of the road for a heart attack, a stroke.
I understand that in terms of the merits, but in terms of the immunity issue, the statute says immune from arrest.
It does, Your Honor, but here the appellant was not immune.
Well, subsequently determined not to be immune, but how are we supposed to interpret that phrase, immune from arrest?
I think I would turn your attention back to the plain meaning. We have to take the language of the statute as it's interpreted to be, and as Justice Meade previously stated, we need to also give effect to legislative intent here.
Well, as the defense said, the purpose of this is to save lives.
Correct.
So doesn't it make sense, given that legislative purpose, to interpret the language broadly?
It doesn't, Your Honor, and it's clear that a narrow application of this statute and not an objective test like the appellant is arguing for would better serve the public purpose, because I would direct your attention, the initial sponsor of this bill, LD 329, representative from Bangor, Cardone, said, you know, this is really about the person at the scene, whether they are the one overdosing themselves, whether they're involved at the scene or they're rendering aid.
Can I ask you a hypothetical question, the dreaded hypothetical question?
Of course.
Here's the hypothetical setting. There's a group of people in a place together, and they're using powerful drugs, and someone goes down, appears to be unconscious. And one of the people there calls 911 and said, yeah, there's a medical emergency at 91 Main Street. And they come and they respond, and it turns out it's a drug overdose, and a lot of people around there, a lot of drugs, and other people maybe under the influence. Does the immunity apply? Notice I said nobody said anything about the drug overdose.
No, Your Honor, immunity would not be invoked in that situation. There was no contextual clues about immunity given, but I want to be clear, we're not arguing for the magic word overdose to be used. It would be enough to say someone is pulled over, passed out, there's a needle next to them, or there are drugs at the scene. What's not enough in this case is someone passed out.
So are you saying that the immunity would apply in that case? I'm not clear whether you're saying these people can be arrested or they can't be arrested. If they just called and said there's a medical emergency, police get there, drugs all over the place, and the guy's down. Can they arrest them all?
No, they cannot. A medical emergency could, as the statute said, the plain meaning, a medical emergency in response to a call for assistance for a suspected drug-related overdose. We have to read it in the context of the entire statute. We can't stop reading it at medical emergency.
Okay, so they can or can't be arrested?
They cannot.
They cannot.
Or sorry, they can. I'm sorry.
Okay,
they
yeah,
can. Immunity does not apply. I
going down the
apologize, Your
wrong
Honor.
road there.
Immunity does not apply. They can be arrested.
Okay.
But doesn't that cut against the entire purpose of the statute? Just because someone doesn't mention in the phone call that I suspect there's a drug overdose, the point is to get medical assistance out to that person immediately and to save that life. And if people make a call and don't mention a particular word, why should that, as long as it's suspected in that person's mind and it turns out to be a drug overdose, isn't that what the statute requires?
The statute does not require, in fact, when they arrive, whether or not there's an overdose. That's immaterial to the immunity determination. What matters is at the outset, the dispatcher, who in their line of reasoning, the law is meant to just encourage them to call for help. We don't want them to be making the calculation, this person's going to get in trouble, I'm going to get in trouble with the law.
Let me make sure I understand what your position is on this suspected and objective versus subjective. I think what you were saying was when somebody calls, they don't have to use the magic words drug overdose.
Correct.
But they have to use words like drugs, or there's a needle next to this person, some language that would objectively make someone, the ordinary human, think it could be a drug overdose. So you're saying that this is an objective test as to what the caller was calling about.
Yes, Your Honor, if you want to put it that way, it's an objective test in the sense that it's whether or not information was given to clue the officer, the responding officer, in that they might be very well responding to
So
drug-related
we're not trying to
overdose.
get into the head of the individual caller as to what she was thinking. We're looking at the language that she used and whether a police officer could reasonably suspect that would be a drug overdose.
Correct. And
What if you get the call in that someone calls in and says, I see a car on the side of the road, I suspect there's a drug overdose, the officer is dispatched, and it turns out the person's just drunk. Immunity?
so in that case, I think we would have to read the plain language of the statute to mean immunity would apply. But again,
But doesn't
Is
that,
the
I would
defendant
bring-
a person who is experiencing in that hypothetical a suspected drug-related overdose?
no, they would not be. And so,
Okay, so that's the immunity, that's the protected person.
That's the key provision, yes. And I would draw your attention to the litany of excluded crimes in this statute. If we were to read this case a month ago, we wouldn't be here because OUI has since been added. The most recent legislature amended it to include OUI as one of the excluded crimes under the statute. And while that's not retroactive, and I recognize that doesn't help the state's argument today, it further underscores the fact that the legislative intent behind this was not to create this blanket immunity provision, but to be very narrow and precise in its application of when and to whom immunity applies.
Can I just take you back? Is there some compelling reason in your mind not to extend the death knell exception to the immunity issue in this criminal case?
Certainly. The death knell exception only applies, as we've said, this court has only recognized it in civil cases. This is a criminal case, and it's when substantial rights of a party will be irreparably lost if review is delayed until final
Well, in
judgment.
State versus Hansen, we recognized an appeal from a denial of a double jeopardy motion to dismiss.
Yes, Your Honor, and I would argue that this case, the right, as appellant claims, to be free from the burden of prosecution is distinct from double jeopardy. We have the right to be free from double jeopardy built into the state constitution, built into the federal constitution. There's no such protection around.
What about being protected from having their liberty interest interfered with while a case is pending, being subject to bail and conditions, et cetera?
Certainly, and those are, very real concerns that underscore the importance of having this immunity statute, and I argue that it serves a very important purpose in that way, but it cannot be extended here. Appellant has done everything they were guaranteed under the statute in terms of moving before trial for immunity determination. That determination was made, and the trial court was clear. There was a medical event here. There was a
But
dispatch.
if the trial
What-
court is wrong, then that means the defendant will be held to stand trial, continue on bail, held to stand trial, and potentially convicted under circumstances which he is arguing statute, the legislature has seen fit to say he is immune from prosecution.
Correct, Your Honor, but he has every right to take this to trial and appeal from a final judgment.
I'd
That
like
is
to
his
take
right.
you back to the suspected drug-related overdose term. Is the suspicion an objective one or a subjective one? In other words, do we look at whether the person who made the call could reasonably have suspected a drug overdose, or do we have to determine that the person, in fact, actually subjectively experienced a drug overdose?
I see my time is, may I briefly respond?
No, you still have a minute, that's
Okay,
yellow.
Excellent, thank you. We care most about we cannot read the mind of Jennifer Dunning, but what we know is this statute is not meant to be invoked by situations like this. There was nothing in her mind that was worried about getting herself in trouble or getting the person in the car, who I don't even think she could see if anyone was in the car when she was driving by, in trouble. And so that line of reasoning does not apply to the immunity.
So in this case, it doesn't matter whether we look at it objectively or subjectively. There's simply no evidence that the caller either actually believed or reasonably could have believed that the person inside the car was experiencing a drug-related overdose.
Correct. In this case, we don't need to know that, but going forward and as a general rule, I'm not calling for whether a reasonably prudent person would think there's an overdose. There has to be that conveyed information from the dispatcher to the responding officer that there's a suspected overdose.
Thank you, counsel.
Thank you.
Mr. Coolidge, you reserved 3 minutes for a rebuttal.
Your Honor, just to briefly address the issue of the interlocutory appeal, I would argue, as I did in my brief, the death knell exception applies. This is analogous to the court's ruling in Hansen regarding double jeopardy.
How should we view what weight, if any, should we give to the fact that the legislature has now excluded OUIs?
I don't think, looking retroactively, Your Honor, I don't think we give any weight to that one for this case. There was I believe there was a case last year interpreting the prior version of the statute that this court made clear that we're looking at the statute at the time it was written. So the court
Well,
would
right, we're looking at it as written, but when a subsequent legislature does something, sometimes they'll say we're clarifying, and sometimes they will be silent. And our case law on what weight we should give that subsequent legislative action has a range. So what is your understanding that we should give in this particular context to that subsequent legislative action?
In this particular context, Your Honor, I would say give no weight to that action because, as I've argued, the focus here is on the caller, not upon the excluded crime. Now going forward, if that crime is excluded by statute, it won't apply.
Can I go back then? As you said, the focus is on the call. Again, going to the statutory language, we've been focusing on suspected drug-related overdose. But it also specifically says that the law enforcement officer has been dispatched to the location of a medical emergency in response to a call for assistance. And that really is terms that seem to, that the reason the law enforcement officer or medical professional is being dispatched is because we believe there's a medical emergency, not just a general, go see what's going on, go check it out. Do you agree with that?
I think it's not just a general check, but I believe that the statement about a medical concern here, I think triggers that language. This is a response to a medical emergency.
But I mean, in this case, the officer certainly didn't respond as though it was a medical emergency, did he? I mean, he just went to see, well, okay, there's a car side of the road, let's go check it out.
I think he responded appropriately, was told there was a concern about a medical event, went there very quickly to assess the situation for himself. And again, I think the rule should be
But isn't medical event different than medical emergency?
I think it could be, Your Honor, but I think we need to interpret this statute as broadly as possible to save as many lives as possible under this. We want a society where people trust 911 or going to the police to be able to get assistance for another person without fear of themselves or the person they're concerned about being arrested and potentially charged with a crime. Thank you, Your Honor.
Thank you. Thank you, counsel, for your argument here this morning. As much as anything for the benefit of the students, typically when we have a new attorney arguing in front of us, we ask them to invite us, take the readings of the court in our conference room. And Ms. Barr is actually a law student. It was her first argument, but we don't count that rule until you're actually sworn into the bar. So we aren't doing that here today, but thank you for appearing here today. As is our usual practice, we're going to take the matter under advisement. The bad part for the students who are here today is you don't get to hear today how we decide this case. We take it under advisement, we'll issue a written decision in due course. And with that, we will be in recess on this matter.
All right.